Hello, and welcome. Welcome to the fourth episode of Feminist Kangaroo Rape Court. And let's just continue where we left off.
She gave a kind of litany of statistics about what's happening out there right now. And I think we should put this up. Sheldon, let's put this graphic up because I think people just don't know that, in fact, sexual assault is far more common than most would suspect. There are relatively few incidents of sexual assault reported to the police. Young and otherwise vulnerable women are most likely to be sexually abused. And most sexual assaults are committed by somebody close to the victim, not a stranger. That's sort of what you'll find if you look online. That is what the major research organizations tell us is the case. Anything you want to quibble with there, or anything that you find doesn't fit with your understanding of things?
Not at all. That's entirely consistent with my understanding, and it speaks to a bigger problem. And here's where I'll respectfully part company with Breeze. We have a lot of fun doing this, and I admire her a lot, but I'm going to disagree strongly with one thing. To hear Breeze talk, you'd think the status quo is fine and everything's hunky-dory. They're the occasional bad actors, but that's the only problem we have. Actually, we have a much bigger problem than that.
It's systematic discrimination against women, I bet.
You think of this in terms of service delivery, and you listen to Marie's accurate statistics about underreporting and underparticipation, we are profoundly failing to serve the victim community with the criminal justice system. And my response to that thesis, we've been tinkering with it for years, getting rid of questions about prior sexual conduct and so on, and the reporting rates haven't changed. I say, after 30 years of reform in a tinkering fashion to the criminal justice system, we need to think more bigly, if I can use that word.
And the reporting rates haven't changed because people still assume that they're going to be put through the meat grinder when they come to court.
Exactly right, and we're still creating a process that is traumatic for victims. So I think we need to, without abandoning fundamental precepts like the presumption of innocence and proof beyond a reasonable doubt, we need to recreate a courtroom that is more sensitive.
I bet that if the courtroom is more sensitive, there are plenty of therapy dogs.
But we also need to think about whether in some cases there are alternative methods that don't involve the criminal justice system. And people may
I want my own kangaroo court. He's saying it.
criticize me for saying, well, you're treating sexual assault less seriously. I say no. If we listen to the voices of victims and give them a healing journey and validation in alternative methods that work for them.
Less seriously, it's actually like way more seriously, because like there's lesser burden of evidence, there's not just so strict procedure than what is in the normal court system. So that's very debatable. That will it be, I think because rape is such a horrible crime that it needs another separate kangaroo court, let's say, that has a feminist judge, and then law not need to apply as roughly and maybe more favor the victim, if I understood it correctly.
Then we are actually treating sexual assault more seriously. I do want to pursue that, but I feel I need to give you an opportunity because I don't think you ever said you're defending the status quo, no. But so you want to take him on that?
Well, I think there's a lot of things we have to ask ourselves about sexual violence and why it's not being reported at the level of some other crime. First of all is, what are the barriers to people coming forward? There are lots of steps in the process before it ever ends up in a trial. In fact, there are lots of criminal matters that resolve without any trial at all. So are the barriers at the reporting stage, sort of at the interface with complainants and the police? Is the barrier the interface with the justice system? Is the barrier the trial itself?
You want to give an example of this?
Well, I don't think we know why it is complainants are deciding not to come forward. Is it that they don't feel they're being listened to by the police and that the interview process with the police is not sufficiently compassionate and understanding?
Well, we could come to some pretty good surmising about why people don't come forward, can't we?
I don't think we can. I don't think we can say it's the process of cross-examination 2 years down the line, that's what the barrier is to people coming forward. I don't think we have a good understanding of that. And I'm not sure we have a good understanding of how many people who have been the victim of sexual violence want to come forward and are not doing that. That's an important question. People get victimized in all sorts of different ways. It's not right. It shouldn't happen. We should actually be focusing, in my view, our attention on preventing sexual violence in the first place.
Sure.
But people get victimized in lots of different ways, and they choose to come forward or not for lots of personal reasons. And I think what we need to know is, why are people choosing not to come forward? Are there systemic problems within the justice system that stop people from coming forward? What are they? And I agree, if there are problems, we have to address them to the extent that we can without compromising an accused person's fundamental rights.
Okay. Good questions. You want to try answering some of them?
There's a lot there. I think women do not come forward because they're not treated with respect. When they do come forward on sexual issues.
Not treated by respect by whom?
Throughout.
Police, courts, media.
Yeah, well, there might
Public.
be, in general,
In
yes. And cross-examination is brutal. It is absolutely brutal. It can be humiliating, and I do not believe that judges are sufficiently interfering and controlling with it, because the Supreme Court of Canada has said cross-examination is one of the best techniques to ascertain truth. I simply do not agree with that. And women do not wish to come forward and have all kinds of aspects of themselves scrutinized in perhaps a bullying and brutal way. Second, it's an adversary system. It's one against the other. When really it's a tripart kind of thing. It's society, the interests of society, it's the interest of victims, and it's the interest of the accused. And quite often, I think that Crown attorneys are not active enough in containing bullying, cross-examination. Witnesses can be cross-examined on minutia of something that might be allowed, when perhaps a simple statement of agreement, yes, I did say that earlier, or that sort of thing. And cross-examination on inconsistencies gets to be grotesque on every little thing. Oh, you were wearing pink pajamas, not blue. And then at the end, every little discrepancy is like a dartboard that somehow you have attacked this person. Who wants to go forward and do that?
Do you think the Ghomeshi trial set back the cause of more women coming forward because of the way all of the public details of the women were put on display?
Ghomeshi was extremely unusual in terms of a sexual assault case. First of all,
Yeah, I would tend to agree 100%, because what, an older gentleman who charms multiple women and gets them to have sex with him and wanting a lot more, and then when they get fed up with it and get angry for him because he didn't want anything longer or long lasting or whatever, then just trying to accuse him of rape, basically. Like, if those telecommunications are to be believed surrounding the case. Yeah, I would say that that's pretty strange when it comes to rape cases.
every single woman consented to the sex. Well, that's not what we're talking about. What didn't they consent to? Assault. Why couldn't he have been just charged with assault, and then you wouldn't have to go through? Well, what kind of sex did you have then? Did he pull your hair before or after? Oh, didn't you say he pulled your hair?
But that is again that you need to make it, because you can't have it both ways. If you want to make there more barriers to question sexual assault victims, or what you can say or what you can't say, or that you need to ask all these questions or whatever, that the truth will come out, then you can't also complain that you want it to be stricter and better for the victim in that way, but then that the process is correctly done, then it would be easier to convict that guy for the breaking of the apartment door, or something different that happened in the same incident or something, you don't get to choose like what law is applied by the basis that how much man-hating is currently with residing in the judge, that you can then choose the category of crime that is different and more easily cross-examined or something. I don't know.
Against the car another time, or whatever it was. Why wasn't it a simple assault case? Who object? They liked the sex. So that can't be used as kind of a bellwether case in that sense, although it was topical and it brought up the pitfalls of cross-examination.
So, David, it did, if I'm hearing the judge right, it did set back the cause of women coming forward because the witnesses, the victims, were put through the meat grinder in that case, alleged.
Yeah,
right.
the Ghomeshi case, and I agree with Marie that it was unusual in certain aspects. What is perhaps a little more typical is that it was full adversarialism on display. And I think to Marie's point, it demonstrates that if adversarialism is our one-size-fits-all go-to to resolve these problems of alleged sexual violence, we are going to continue to underserve victims, and we are going to continue to overlook the nuances of truth that we need to be delving deeply into.
Let's go where you wanted to go a few minutes ago, which is to say, if there's a better way, can we kick around some ideas here about a better way to do this? What do you think?
Yes, I've written about this. I think that there should be a range of options for complainants who have real choice in the matter. I am firmly committed to the idea that the public prosecutor should remain involved, but there are some cases for which the traditional criminal justice system will be appropriate. Prison is an obvious need in a particular set of facts, and so you need a full adversarial trial with all the protections for an accused. There may be a range of cases where victims say, look, I don't care if he goes to jail. I don't care if he's on the sex offender registry for life. I want validation. We may be able to look at a publicly carried forward civil suit where the burden of proof is less. There's a requirement for the accused to get in the box and give his side of the story.
Publicly approved kangaroo court where the burden of proof is lessened, etc. Yes, that is exactly what you are supposing. Doesn't sound somehow right.
It's an option right now, though, isn't it?
Only if the complainant has the resources to fund it privately.
I see.
And when the damage awards are $50,000 for sexual assault and you have to pay your lawyer $250,000,
Right.
it's a non-starter.
Right.
So I say a public option where the Crown Attorney can sit down with the complainant and say, we could go civilly, we could go criminally. Here are the advantages and disadvantages of both. And then a third dimension to the different opportunities we might have would be a more sort of
You want to provide the victim a menu of choices of like kind of how much into trouble and how serious she thinks that the sexual assault was. That's interesting.
restorative approach. However that looks like, whether it's a healing circle in Aboriginal communities or something like it in other communities, people are exploring these issues of sexual violence, the social impact, the personal impact, looking at consequences in a more limited sense, but nonetheless sending a public message that this kind of behavior is wrong.
Can I just understand that? Restorative justice, would that involve the assailant and the victim being in the same room at the same time?
You could structure it any way you want. Sometimes in tough restorative processes, you have it's like shuttle diplomacy back and forth in rooms and so on. Will there be an acknowledgement and so on? We saw the nascent beginnings of that in the last Ghomeshi prosecution, where the prosecution peace bonded the case, but Mr. Ghomeshi also issued an apology. Mm-hmm. That, to my mind, was a sophisticated use of the current limited tools to try to move beyond just a purely winner-take-all strategy. The charge was withdrawn, but there was an apology. The complainant in that case was able to stand on the courtroom steps and say, here's what happened to me.
And she did. She quote unquote held court.
Held court.
Yeah.
So we see the players in that case groping towards some kind of resolution that is a little less winner take all. And in the context of sexual violence in a social relationship, where those relationships may be ongoing, that may well be, for some complainants, the best approach.
I got to get Brice on this. How much of that can you sign on to?
Well, I think when you're thinking about structuring different models, if we're sort of blowing up what we've got now and thinking about what's the best approach, you really have to ask yourself, what do you want the end result to be? And I agree with David to a large extent. If you want the end result to be punishment and the potential for jail, deprivation of liberty, stigmatization with a criminal record, I don't think we can do away with any of the procedural protections we have now.
So what can we add to it?
Innocence. Well, but I also agree that some people don't want that. Some people want something different. We currently have a civil system. Complainants can sue people civilly. We don't have a well-developed sort of alternate restorative justice approach, but we have diversion available from the criminal justice system that could be more developed to be more restorative.
What does that look like?
Well, I mean, it could look like a sentencing circle, as David has suggested, of some sort, or some sort of mediated resolution system, which happens in other systems. The problem that I see with creating alternate streams of resolving interpersonal sexual violence is you can never guarantee an outcome. All we can do is design a process that is fair and respectful. So you can never guarantee to a complainant that she will be satisfied by the outcome of whatever process you put in place, whether it's criminal or civil or something else. And so then you have to ask yourself, well, if a complainant, presumably a new model would be complainant driven. The complainant gets to decide, maybe with the advice of counsel, which route they want to take. The problem is, what do we do with the outcome of that if the complainant is not satisfied? Can the complainant choose resolution, and if she's not satisfied with that,
Go back to court.
Then go to civil,
Yeah.
and if not satisfied with that because we have no statute of limitations, go through the criminal process? I think that's really problematic, and it's problematic for one important reason. Anything an accused person says to anybody outside of a courtroom is admissible against them at a trial. So if you want a restorative justice process where people have an open dialogue about what happened, educate an accused person about what happened in their experience and get them to understand it and come to some agreement, that's going to involve making comments and talking about what happened. And you have to do that in a way that doesn't ultimately jeopardize the accused. You can do it. But I think there are a lot of problems that would have to be worked out to make sure.
Let me guess, I'm just running out of time here, and I want to say, do these problems hamstring inordinately your ideas of
Okay, so tip number whatever, if you ever happen to go into a kangaroo court, then make sure that it doesn't happen that if you kind of are in some kind of a restorative process of restorative justice process or whatever, then that basically if you talk about your experience and how she felt victimized, etc., that while listening that and talking about it, that then like it will nullify your protection in a real criminal case, because I presume that you are not allowed to say it again if you heard or said something about the victim's past, because then that would be something, and you've heard it in that kind of process, so you shouldn't repeat it. I'm not sure, but like that, if you could just take the kangaroo court, and then if you are not satisfied with the kangaroo court goings, then take it to the real court, then now there might be a problem that you can't say, or some things can't be evidence anymore because you talked about them in the kangaroo court. So be careful of that.
alternatives?
No, because I'll say I agree with Brice. I don't think somebody should have the option of being, I'll try this, and then I'll try this, and then I'll try that. That creates more problems than it solves. So there should be an informed choice at the beginning, and access to counsel to make an informed choice and so on is essential.
Marie Corbett, let me get you to weigh in on this notion that was raised in the previous interview of We can have an adversarial court system to deal with robberies and murders and white-collar crime and drugs and all that business, but sexual assault is a crime of a different nature. And we might actually be better off having just a completely separate wing of the courts, if you like, or division of the courts, dealing with only those cases where all of the issues that we've talked about here, added sensitivity, higher respect for the woman testifying, could be brought to bear. What do you think of that idea?
I think you could have a dual system. For example, we have crimes, which is federal jurisdiction, like criminal negligence causing death, and yet you still have careless driving under the Highway Traffic Act. I don't necessarily believe that it should be a civil system exclusively for certain domestic violence crimes. I think you could have regulatory offenses and a regulatory court, perhaps called the domestic violence court. Take out the word sexual out of it, and start it off with it's being available to assaults that occur where people are living together. For example, with children or spouses. Oftentimes, the people involved do not want lengthy sentences, and yet if you had another system provincial-wide, then you still had the opportunity to have a limited range of sentencing. You could be fined, or you might have 6 months or something like that. Not only that, if it's at the provincial level and it's people living together who know each other, there's greater access to the social services needed for remedial action.
Anybody suggesting this, or is this under discussion anywhere to your knowledge?
Well, the first time I heard about it was from David Butt, and so I've been thinking about it ever since. And something has to change, because the criminal justice system as it is too big a mallet for what we're trying to do, where the people involved are people who know each other. I mean, if you are out walking on a street and some stranger attacks you with a knife and rapes you, well, that's the criminal justice system. You'll get DNA and whatever. This isn't what we're talking about here. It might be a husband and wife, and they've had sex all along, and then she doesn't want to have it. You know, you can't bring in all of the safeguards and the heavy hammer of criminal law in those cases when basically you're interested in a resolution. And so that's why I think that something equivalent to lesser offenses confined to certain situations, but still having significant penalties as opposed to being merely civil is a step in the right direction.
So we need alternatives. We need a different and better way of handling things. How much appetite do you think there is out there to try experimenting with something new?
I don't think it has to do with appetite. I think it has to be done. It's a social necessity.
But at some point where the rubber hits the road, the government has to make a decision, either we're going to do this or we're not. So how much political input is there behind this to make it happen?
Well, I would hope that there is a lot from, I think that a lot will come out of the report of the Canadian Judicial Council into the after the Justice Camp inquiry. I think it has been in the media on page 1 almost ever since the Gomeshi trial, and it hasn't gone away. And then not to mention the boys will be boys, and it's locker room talk that is also the subject of popular media.
I have never heard the expression locker room talk more than in the last 3 weeks, for we know why.
Yes. But it's been there, you know, in the RCMP, in the military, we're talking about the lack of respect for women, basically, you know.
I've got 30 seconds, David. You take it.
Yes, I think that Marie is absolutely right. Action is inevitable because there has been, the statistics about underreporting have been around for decades, but it's only in the last couple of years that there has become widespread frustration and, dare I say, even fury with the status quo. And I think it's incumbent on our political decision makers to react to that new reality of we're not going to take this anymore.
I want to thank all three of you for
justice.
coming in and having a very enlightened and civilized discussion about a very, very tough topic. Marie Corbett, the former judge, I hope we're going to see you on this channel again.
I hope so too. I didn't say all I wanted.
Well, we never do. We never do. There's only an hour. David Butt and Brees Davis.
Thank you.
Spelled Davies, but pronounced Davis.
That's right.
Just so the people at home know that I'm not mispronouncing your name.
That's right.
Thanks so much,
Thank
everybody.
you.
Really appreciate it.
Pleasure, Steve.
Help TVO create.
By the way, I don't know if I can find it. It might be a bit hard, but
Census
just that this must be some quite angry feminist because she has been sticking her nail into her hand, driving it through the whole time, presumably when everyone else was talking about things she did like, and it's all bloody and gross. But yes, this was the feminist kangaroo court, and maybe you'll have some good wide old guilt when you have the stigmata marks on you when you leave the debate about sexual violence in the courts. Very odd, very cool, and thank you for participating. Next time we look at another case of freedom of speech coming in contact with new type of hate speech law, which we haven't seen before, and it's kind of like a different different situation and different type of attack on the fairness of law, I guess. But we will see next time.